That's right, ladies and gentlemen. We are back. Today is September 16, 2017, and we are an attorney LTC segment. And to the left of me here is attorney extraordinaire Benton Ross Watson. Ross, how you doing today, buddy?
Man, I'm doing great. Glad to be back. Rick came in, had some good segments, took over, and
You guys are a tag team match, man. When one's up, the other one's down, the other one's down, the other one's up. You just tag it out. You come in there, you're good to go. Let me just give a quick highlight of what we're going to go over here. We're going to go over Penal Code 931 and 932, self-defense and deadly force in defense of a person. Now, I teach this very often, and sometimes the lines can get blurred for even me. So Attorney Watson here will break it down, answer questions, and clarify which needs clarifying, not which needs clarifying. So, ladies and gentlemen, it would behoove you, if you're a licensed to carry individual, or anybody for that matter, has a question concerning this particular area, to give us a call at 254-697-6633. So, Ross, with that, why don't you take it away and tell us what you got going here?
yeah. So I think a lot of times when we get into these self-defense cases, we have a lot of people. Maybe not a lot of people, but I know that there are some people that get on the juries, or at least the veneer, however you want to say it, French or Texan, that think, well, if you're going to do a self-defense case, that's just stupid because, you shouldn't have put yourself in that situation, and I don't even understand. You're guilty, in my opinion. And so I think I want to give some examples, too, about why it is that we need self-defenses. Bad things happen to good people sometimes, and good people get put into situations that they should not have to deal with. And innocent people shouldn't be. Maybe anything can go wrong. And so I kind of wanted to give an example about what just happened to me. And I realized that in some of my youthful days, some people probably, if you know who I am, know I was a little bit rambunctious, okay, so to speak. But those were a long time ago. And I think that just last month, I'm in a situation where I'm in my professional capacity, and I had a lot of things in my life put at risk, and that's because I went down. A good friend of mine had gotten into college down in Houston, and we went to go move her into her apartment, and she lives close to the downtown area, kind of the midtown section, and so we went all day and the day before, and we moved all this stuff in. We were absolutely exhausted. It's about 9:30, 9:45, and she doesn't know anything about Houston, and I'm from there, and I said, well, let's go down there, and we went to some restaurant. Some guy was like, man, you got to go to this rooftop wine bar. It's not really a bar. It's just kind of real quaint, nice, quiet place. You can have smoked cigars and have a glass of wine, and it's a really great and beautiful view. And they showed us a picture, and she's like, oh, that'd be really cool. What time do they close? I think they closed about 11 o'clock, and so we still had time, and that was on the way home. So we were walking, and we hadn't had anything to drink at all whatsoever, no alcohol at all, and we're walking. And we think we get to the address based on Google Maps, and we go in, so to speak, and we get to the top, and we start hearing this loud rap music and all this stuff going on. I asked her, this doesn't sound like the place we thought it was. And so we get there, and sure enough, it's just a bunch of college students getting naked, dancing on the tables, just acting a fool. There's all kind. We potentially smell something being smoked on the outside balcony of this place that probably wasn't legal, and is extremely loud music, and like I said, mostly drunk college students, and we did not want to be there at all whatsoever, and so we immediately wanted to leave, but she said, I have to go to the restroom so bad. So she goes to the restroom, and she comes out of the restroom, and we are leaving. We are walking out the door, and some drunk girl just falls down right in front of the door to the stairs, and we're waiting on her friends to come and try to help her up and drag her out of there. And in doing so, some really young, fit Mexican guy, about 6'2", right, pretty big guy, just comes up and, really hauls off and pushes me. And honestly, I just ignored it, acted like it didn't happen. I felt kind of like a wussy because I just kind of like, okay, whatever. and then the dude pushes me again hard, where I almost kind of fall into everybody, and I turn around, I was like, man, what's up, man? And then the guy says some kind of name like Ricky. I think the guy thought I was somebody else, okay? And just starts throws a punch at me. And so going back to my amateur UFC, right? I grab his fist and I put his face into the wall. Okay? I mean, it was a quick reaction, right, to dodge a punch that would have otherwise hit me in the jaw, and I have paid a lot of money for these teeth.
They're such pretty teeth, too.
Yeah, and so I'm not going to let him hit me in the mouth again. And yeah, the guy goes down hard, okay? And the next thing I know is I'm being detained by police, and there's a bunch of girls all of a sudden screaming that I started it, and I punched him, and I was hitting him, and I was being a butthole and all kinds of other stuff. And so I'm not saying it's because of race. I know what you said, but it was 2 Mexican cops. It was a bunch of really attractive Mexican girls. Don't know if it had to do with race or if it more had to do with the attractive women, okay, from the other side. And the other guy was hurt pretty bad, right? But they were going to arrest me. And it looked as though that was going to happen, except then a sergeant came on scene. He was a black gentleman. And so at this point, I already thinking there was at least a suspicion in my mind. Oh, I'm a white guy here, right? These are minority cops. They're probably on a minority person who's saying it's my fault. And thank goodness, right, that this sergeant knew what he was talking about. And he starts talking to me, and then he goes over and talks to the other guy. And he comes back over and he's like, "You hadn't had anything to drink, have you?" And I said, not one sip. And he said, "Your story is the only one that clearly makes sense, and none of those other stories match up, and I don't even know why we detained you. Just get out of here." Okay? But for those 15 minutes, you can imagine the sort of the even fear that came over me. If I get arrested for this, this is really going to affect my career, right, and my whole life is on the line here. And I did absolutely nothing wrong at all whatsoever. And so technically, I suppose that they could have charged me because self-defense is only an affirmative defense. And I had nothing to do at all whatsoever with this guy's issue with whoever it was that he had. I was only there not even for 5 minutes, if that at all. And we're leaving. And so these things can happen to anybody. And all it would take is for one police officer to believe somebody else over me. And it's the same with a jury.
Wouldn't it be lovely to go to a white, a Mexican, or a black, or whatever color you are, officer, and not have to worry of what you said about minority this or minority that, and just have to worry about if your actions fell in the proper groove of the law? Wouldn't that be nice?
I knew that mine did, and so I was confident. And
I know, but everybody worries. Both sides of the table always worry. Well, am I a minority? What color is the cop coming? I mean, it's just, that's why I broke these sticks. I'm like, let's get rid of the color, man. It's got nothing to do with color. And if everybody does that, we'll be all right. But that's not going to happen.
And so I'm saying, I'm not saying that those were issues. I'm just saying that they were legitimate worries that I had down underneath. And I don't know. And it looked to be playing out. It was either one of those two, maybe a combination of the girls and the everybody was the same race that was involved in coming. Maybe although there was all kinds in that club. Okay, but I mean, anything can happen is what I'm trying to get at. And so we never know. Life is such a series of unexpected events that we have to make life choices about often, and we don't get a lot of time often to determine what we're going to do in a situation, and it's necessary a lot of times to protect ourselves when we get into those situations. And so, I mean, that is why we need self-defense in the law. And there's other cases that aren't as good as mine. There's sometimes people put themselves in a bad position, knowing what position they're getting in before they get there. But self-defense still serves its place. So if you're ever on one of these juries, if you're ever in a situation like that, or you're in an environment or proceeding where you have to make some kind of determination, don't take it so lightly, because it is a serious deal. And you had asked me, I think, to prepare for this, what about, we talked about threats. What if somebody is threatened? Could I have hit that guy earlier? Possibly.
Preemptive strike.
Possibly. When he pushed me the first time, I may have been, at that point, allowed to use force to dispel any kind of threat that was coming my way, and I probably could have done that.
I'm talking before that, though.
No, I know, but I want to go to I want to go in incremental steps here. So on the first push, let's say that I hit him, then hit him, didn't even throw him because I never hit the guy. But if I had hit him, I think I could do that because the code says if I reasonably believe that force is immediately necessary, okay, in response to the other person's use or attempted use of unlawful force. And so he had used unlawful force against me, and I had a right to be where I was. I was not violating the law by being where I was, and so I would have had a right. I would not have had to retreat, and I would have had a right at that point to defend myself, even at that standpoint. Okay, and so what about though when we get into, like you said, if somebody is if it's verbal only? And this is a really good question, because the code says that you cannot use, right, self-defense, force in self-defense for verbal provocation alone. And so you ask yourself, what is verbal provocation? Okay, it's funny because the jury instructions that we work off of actually say, is the force justified by words or acts of the other person? Well, if it's words, it's verbal provocation. And so at the same time, a lot of these jury instructions don't match up to what the code says. And so we get a lot of times into these really tough cases about where we have ambiguous conduct with no actual step towards somebody, an actual use of force, right? Maybe somebody is walking in a threatening manner or something and not saying anything, but saying something with their actions, so to speak. Maybe we get somebody who's saying, "You ready to die, boy?" or something like that, you know? And like this guy's yelling, "Yo, what's up, punk? I'm coming out, I'm coming out." What if somebody's doing that? Okay, that seems like it's threatening. Are they doing action with the threats? And what exactly is the threat? And so we talked about before on the show the Hudland case, where it was some bird feeders. Remember, it was neighbors really feuding back and forth, and one neighbor knocked over this guy's bird feeder, you know, several thousand times or something like that. It was just outrageous number of times. And finally, the guy just gets really upset, and he goes over and confronts the neighbor about it, knocks on the door. "You knocked my bird feeder over again." And the guy doesn't deny it. Doesn't deny that he's doing it. Just starts really just laughing at the dude. And so the guy takes his broken pieces of his bird feeder and just throws them in the guy's face, right? And so then that guy starts attacking the neighbor that threw the plate at him, and he sicks his dog on him. And we talked about it. Then he sicks his son on him. The guy ends up getting, the guy that had his bird feeder knocked over, ends up getting choked out in the middle of the street by the guy's 16-year-old son. It was a really bad day for that guy, and he got convicted of assault. But the reason he got convicted of the assault and he could not use a self-defense is because the guy merely laughed at him. There was no reason. He was trying to say it was self-defense, but but really the guy didn't do anything other than just really piss him off. Okay? And so he threw the plate because he was upset that the guy was laughing, and he didn't deny. It was obvious that he did it because he just starts laughing his butt off. So that is verbal provocation. He's laughing. He's just provoking that guy. But then we talked about Hamel, and that was when the gentleman helped the girlfriend who was getting beat up by the boyfriend, and the boyfriend comes over there looking for the girlfriend, and they're trying to move her out, and he's like, "Where's that bee?" He's saying expletives. And then the father-in-law of the guy who's moving the girl out comes in with a tire iron. "You need to leave." And then the bad guy says, not the defendant, but the bad guy says, "You better get your old man, or I'm going to shoot him. And I got the gun in the car." Okay. Well, he says, "You need to leave." Well, then he turns around and starts walking, and the guy that's helping, the guy that's the defendant, then takes his knife, remember, and stabs the dude before he makes it to the car. And remember, he was on appeal because they denied him a self-defense instruction at trial because they said he did not actually use force or attempt to use force. And so the court said you don't actually have to, right, that use. It wasn't verbal provocation alone. He had some action involved, and he didn't actually have to be going to get the gun in the car as long as the defendant reasonably believed an apprehension of danger that he would go get the gun. And in fact, that's probably what he was going to do, but there was no way for anyone to prove that he was going to get this gun in the car. In fact, they didn't even have evidence that there was a gun in the car other than his threat. Okay, and so that was a good case, but obviously that was a close case because it goes on appeal, and I don't think that's even a close case. some dude makes a threat, says he's got a gun in the car, and then turns around and starts walking towards the car, I feel like I better do something. That guy didn't know where he was. He knew he couldn't retreat. He couldn't get out of there. He didn't know that house. He was just helping that woman. Okay, and so he stabs the guy and prevents him from getting to the car. And it was clear that's what he was trying to do, because as soon as the guy started walking elsewhere, he stopped his attack. Okay, and so, but that court says something that really irks me, because in the bottom of the opinion, they talk about a threat. They talk about he threatened them. The court considered this man's words to be a threat. And then they said, but these weren't words alone. His action in going to the car allowed him to give rise to the use of self-defense. But hold on a second. A threat of deadly force, we know, is the use of force. A threat of deadly force is not deadly force, right? If it's only to show the person that you're, communicating the threat to, that you will use deadly force if necessary. So if a threat of deadly force is by definition force, then it is a use of force. So why does it matter whether it is words or conduct if it is words and it is use of force, and i.e. a threat to use deadly force? I know, right, it should have been justified regardless of the guy's actions. If it truly was a threat to kill his father-in-law or him, right, then that was a use of force.
See, that's what gets me going here, man. You've got all these different ways to look at it. You said it earlier in this segment how it says you can't attack based on verbal provocation alone, but then again, that when they give you the orders in the court to look at things, it includes actions or words can be.
And it says or,
right.
So making it seem like it could be words by themselves.
That puts the people out there on the street always going to question whether or not what they do is right or wrong based on who's judging them, looking at them, what's the attitude of the court, the opinion of the court, what's offered in the court as evidence, the whole works. You never know anymore, do you?
Right. I think that, some cases, but then there are cases that should be clear and they're not.
Let me ask you a question. Let's put that scenario that you had about the guy going in the car and he gets knifed. Let's put it in a simpler term that I think a lot of people can do it. Somebody comes up to you and you're face to face and they're threatening you verbally, and they're in your personal space and they've got their arms up and like this kind of stuff. You never know when the sucker punch is coming. Wouldn't that be equivalent to the necessity of a preemptive strike? Like, whoa, he's talking it up. He didn't actually do anything except his actions show, I don't know when it's coming, but I see the shot. I'm going to knock him in his jaw.
And so there's really no way for me to answer that question in the general terms that you put it. But I think that what you're going to have to do is say that you had a reasonable belief that the force was immediately necessary, right, to respond, right, in defense to the other person's use or attempted use of unlawful force.
And your hope is in that the reasonableness of the jury will see it your way.
Yes, and I also think, like, so if a threat of deadly force merely constitutes non-deadly force, the use of non-deadly force, what is just the threat of force? Is that anything? Because you take a step down, see? If I make a threat of deadly force, okay, just that I will use deadly force if necessary, then that is only, by definition, non-deadly force.
I can't tell you how many times people tell me that a jury's given a question to answer, and all of a sudden their answers are based on opinions, morality, and all this kind of stuff, not the answer to the law, the legal question. So it's like, you don't know what's going to happen. You have no clue. You could study this, and like, we're trying to be good law-abiding citizens to learn the law because it says it in black and white, and we go out there and we get screwed anyway. It's getting to a point where it's ridiculous. Ross.
And so, yeah, and so it's college football. In college football, right? I'm 5'9", I play fullback, and I play defensive line. That's just insane, right? How can you play college football? I'm almost 5'10", but still, I'm almost a foot shorter than everybody on any kind of line anywhere. Okay, I had a recruiter, side note, from UT tell me if I was 6'1", I'd be the number one recruited guy. But he's like, you're not even tall enough to be recruited at all. So I kind of but I did play, and so I understand the preemptive strike very well. And when I played college football, you have to remember fighting really wasn't as looked down upon as it is now. But oftentimes I had to stand up for myself, and that required a preemptive strike, mainly because if those big guys got the first hit on me, I probably wouldn't stand a chance after that. And so trust me, I understand more than anybody about getting a preemptive strike to control the situation. And I think you're going to have to determine, right, exactly if it was necessary though. Into those situations. So when you say that they're bigger than you and they're confronting you, I would say that when they're confronting you, that's not verbal alone. That's not verbal provocation alone. That is some conduct. Okay, if they're walking back and forth, pacing, or they're looking at you crazy and like walking towards you, that's some conduct involved there. But then we have cases that there's another one that's called a tabler, where a gentleman said, "I'm going to wipe your family out for less than $10," and the guy lures him out 2 days later to a parking lot and kills him. But the thing is, and they say he couldn't use self-defense because that was just verbal provocation, and the court said we don't, and this is what makes it ambiguous. The court said we don't even think that qualifies as verbal provocation. Well, even if it's verbal provocation, that doesn't give him right to use self-defense. So I think what the court actually meant was we don't think that qualifies as a threat. Okay, but even if it did, that guy was so bad, he killed like 5 or 6 people. Okay, and I mean, the guy really had no business killing any of those people that he did, and so those courts are not gonna try to make the law work for him. Okay, but those statements that they make just make it ambiguous for everybody else. And so at what point, I mean, I think intimidation is a factor. I think, like, obviously I was great friends with Big Lou, but I could see a situation. Big Lou was on my college football team, the biggest guy in the NCAA at one time. He's like 6'9", almost 500 pounds. Right? And I'll tell you, Big Lou actually got shot 3 times in the same night when he was a bodyguard, and took all 3 bullets, chased the guy down, took his gun, and the guy got arrested. So obviously Big Lou, right, can take a whole lot more, right, than I can, right? And Big Lou probably doesn't have to do a lot to end my life.
That's right. Yeah.
Okay, it probably doesn't take him a lot. And a gun, obviously, is not as effective on Big Lou as it probably is on everybody else, seeing as how I can tell you 2 of those shots were in his neck, and it still didn't stop him. Okay, and so I can tell you that this is, I mean, yes, it just is a fact-intensive situation, and you've got to be pretty confident that in the situation you're in, it was necessary. There's no doubt.
You just said something. In my classes, I train these people, my students, to never think about the gun. You should never think about the gun. You should be so familiar with the gun that all you have to focus on is the threat. Now it's got to the point where the student is so proficient with the gun, doesn't think about the gun, and only thinks about the threat. Now they got to say, if I do this, is this going to ruin my record? Will this follow me for the rest of my life? Will I pay $50,000 in attorney's fee? If I'm not going to die, I don't care. If I'm going to get beat up a little bit, should I do this? Am I allowed to do this? Am I in a proper place? Then I got to start thinking, okay? Because I do not want my lifestyle, my economics to change because of some dirtbag. So I've got to, do I really want to do this? Do I want to get into this? Which puts me on the weak side of the situation. Now, there's some other people who don't care, and they'll just do it, and they deal with the consequences. I know what the consequences are. They're life-changing. So you got to be careful.
Yeah, I mean, and that's what I'm saying. You never know when you're going to get put into a situation like I was in, where you're going to have to face a threat, and you're not going to have very much time. If it is truly a threatening situation, a lot of people get into tense situations that they actually could get out of if they would just be peaceful about it.
Non-violent dispute resolution.
Okay, right. But if a lot of times when you do get into a violent situation, one, you don't have a choice, you're not going to have much time to make those decisions. And so it is important to try to stay focused on the threat and to try to determine, right, the proper course of action to take.
But what's frustrating is you read the law that's in black and white, and you understand the little slight gray areas of reasonableness, what's reasonable to one person, so on and so forth. But when we come to learn how all these different factors come into play in the courtroom, it dilutes, distorts, perverts what you're reading here in black and white. So a person who's really trying to do their best has to contend with the attitude or the opinion of something that they're not prepared for in the courtroom. It's
Right.
like, how do you get yourself ready? There's no way to get ready.
And so you see, in my situation, I had followed everything exactly properly. Everything was exactly perfect, which is probably the only reason, right, I got out of there without any problems. Had there been one fact that I had done maybe wrong, right, I would be left with a situation where the police officers, right, could take the word of anyone else, right, and I could have done whatever they wanted to me. And so it is important to be following the law and to know your rights and to do to follow incremental steps. If you're in a place where you have a right to be and you're not violating the law and you haven't provoked the situation, then you have a right to use self-defense. Otherwise, right, it's a gamble.
There you go. That's the way to end it, man. It's a gamble. I mean, because if you're not 100% right, it's a gamble. So I guess you have to determine the line in the sand, ladies and gentlemen. You all have your own line in the sand. You know when your head's going to go into the bow of the boat. You'll have to make the decision. So you got any questions, give us a call. 254-697-6633. We're going to take a break. And when we come back, we'll be going over points of interest, and we will have tactical snack. Thank you, sir.